counts would vacate. So those would be removed. Okay. Mr. Hill, do you understand that?
Yes, ma'am.
Mr. Campbell, do you understand that?
Yes, ma'am.
Okay. Do you understand that by entering into a guilty plea, you are giving up the following rights? I'm going to read you a list of rights, and at the end, I'll ask you whether or not you understand it. Okay. You have the right to a trial by jury. You have the right to have the evidence against you proved beyond a reasonable doubt. You have the right to remain silent or the right to testify should you so choose. You have the right to confront and cross-examine the state's witnesses, as well as any other evidence that would be presented against you. You have the right to be represented by an attorney at that trial. If you cannot afford to hire your own attorney, you may have one appointed to you at no expense. You have the right to subpoena your own witnesses to come to court and testify on your own behalf, as well as the right to present evidence on your own behalf. If you were to be convicted, you would have the right to appeal that conviction with the assistance of an attorney. Do you understand these rights? Mr. Hill?
Yes, ma'am.
Mr. Campbell?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up these rights? Mr. Hill?
Yes, ma'am.
Mr. Campbell?
Yes, ma'am.
Has anyone forced, threatened, or otherwise made you enter into this guilty plea? Mr. Hill?
No, ma'am.
Mr. Campbell?
No, ma'am.
Do you understand that these convictions can be used against you in the future as use of evidence of a similar crime in a future case, for impeachment of your testimony, or to enhance a future criminal sentence under the recidivist statute? Mr. Hill, do you understand that?
Yes, ma'am.
Mr. Campbell, do you understand that?
Yes, ma'am.
Do you understand that if you have any open cases, suspended sentences, or are currently serving on any term of probation or parole in any jurisdiction, including federal court, a conviction in this case would have a negative impact on those sentences? Mr. Hill?
Yes, ma'am.
And Mr. Campbell?
Yes, ma'am.
And Mr. Campbell, correct me if I'm wrong, but you have already been revoked on your open probation. Is that correct on the 16 SC case?
Yes, ma'am.
All right. Do you understand that if you are not a United States citizen, a conviction in this case would have a negative impact on your immigration or visa status? Mr. Hill?
Yes, ma'am.
Mr. Campbell?
Yes, ma'am.
Do you understand that you have 4 years from today on any felony charges and 12 months from today on any misdemeanor charges to file what's called a habeas corpus petition? A habeas corpus petition is a document that you can file to challenge whether or not this plea was voluntary, and you have those time constraints in order to file that. Do you understand that, Mr. Hill?
Yes, ma'am.
Mr. Campbell?
Yes, ma'am.
Thank you. And Mr. Hill, are you asking to be treated as a first offender?
Yes, ma'am.
Okay. Just so you understand, and has Ms. Snyder explained to you the First Offender Act? I'm sorry, Mr. Hubbard explained to you the First Offender Act. My apologies.
No problem.
So you understand that whether or not you will be sentenced as a first offender is discretionary and up to the judge. However, if the judge does decide to sentence you as a first offender, you will be sentenced under the First Offender Act, which means that if you complete the terms of your probation and the terms of your sentence, you can ask for that conviction to be discharged at the end of your probationary sentence. However, if you do not follow the terms of your probation, you can be revoked and resentenced up to the maximum on each charge. Do you understand that, Mr. Hill?
Yes, ma'am.
And do you understand that if you complete the First Offender Act, you can honestly answer any question that you've not been convicted of a crime? Do you understand that?
Yes, ma'am.
Do you still want to be treated as are you still asking the court to be treated as a first offender?
Yes, ma'am.
All right. So as to the charges on the indictment as they pertain to you, Mr. Campbell, how do you plead? Mr. Campbell, are you entering a guilty plea to the indictment?
So, Mr. Campbell, this is the point where you let me know on the record if you're entering a plea of not guilty, which means you want to have a trial, or instead entering a plea of guilty, which means you've now pled, and at the appropriate time, I'll talk to you about what I think a reasonable sentence is. You still have your ability to withdraw the plea if you are unhappy with the sentence that you get, but the way we move forward from this juncture depends on how you answer the question. It's not a trick question, it's just I'm pleading guilty because I'm ready to move forward, or I'm pleading not guilty because I want a trial. Does that make sense?
Yes, sir.
Okay, so at this point, are you pleading guilty to the charges in the indictment that name you, or are you pleading not guilty?
Yes.
Okay.
All right. And Mr. Hill, the same question to you. Are you entering a guilty plea to the indictment? And Mr. Hubbard, correct me if I'm wrong, but he's entering an offered plea to count 8 for the aggravated assault?
Counts 7, 8, and 9, all dealing with the incident that occurred on the 25th of January, 2019. We're going to offer an offered plea to those and a guilty plea to the other charges as charged in the indictment.
Okay. Mr. Hill, did you just hear what your attorney said?
Yes, ma'am.
Is that your understanding of your plea?
Yes, ma'am.
So you're entering a guilty plea to all counts with the exception of counts actually 6 through 9, which you're entering an offered plea to?
Yes, ma'am.
All right. Thank you very much. Your Honor, if this case were to proceed to trial, the state would show as follows, and this is going to be quite lengthy, and I will try to spell all the names for you, Sir Court Reporter. On January 15th of 2019, Atlanta Police Department officers were dispatched to a residential burglary at 3546 Roswell Road Northwest, which is located in the city of Atlanta in Fulton County. Upon arrival, officers spoke with Veronica Cristiano, that's spelled Christiano, who stated that she and her partner were asleep in their condo townhouse when they were woken by their garage door. She said as they looked outside, their vehicles were being stolen. Their vehicles were an Audi A4 and an Audi Q7. Ms. Cristiano said that her Audi A4 was parked directly in front of the garage door and had the garage door key inside of it. It was unlocked. The defendant and an unidentified co-defendant then entered the garage and stole the Audi Q7 that was parked inside.
When you say the defendant, which?
Defendant Hill, I apologize, Defendant Hill.
Okay.
The Audi Q7 was recovered abandoned down the street. The Audi A4 was not recovered. However, the key fob to the Audi A4 was recovered in the possession of Defendant Phillips on February 4th of 2019. Subsequent surveillance footage that was obtained by APD after January 15th, 2019 showed 2 individuals climbing over the fence at 3546 Roswell Road. Detective Thonkoff, that's THONGKOTH, with the Atlanta Police Department, recognized Defendant Hill from the video. And that relates to counts 1 through 4, Your Honor. As it relates to counts 6 through 9, on January 25th of 2019, Atlanta Police Department officers were dispatched to 205 Pineland Road, which is located in the city of Atlanta in Fulton County. Upon arrivals, officers spoke with the victim, Ms. Cheryl Wyndham. Wyndham is spelled W-I-N-D-O-M. Ms. Wyndham reported that she heard her dog barking and then heard her car start. Ms. Wyndham stated that she then saw her vehicle, which was a 2006 Infiniti QX80, leaving her garage and went outside to try to stop the vehicle from leaving. Ms. Wyndham stated that the driver of the vehicle drove the vehicle at her, knocking her to the ground when she attempted to intervene. Ms. Wyndham, on the surveillance video that was subsequently provided, was within 6 feet of seeing the driver. She was actually on the driver's side when she was hit by the vehicle. She was not injured as a result of that, physically injured. Ms. Wyndham identified that there was a white vehicle waiting at the bottom of the driveway during the theft. After leaving her property, they went west on Pineland and towards Northside Drive. Ms. Wyndham provided surveillance video from her home that captured the aggravated assault. Her driveway is well lit, and she did have an opportunity to view the driver of the vehicle, who she subsequently identified as Defendant Hill in a 6-pack photo lineup shortly after this crime was committed. Her garage door opener from her son's vehicle that they also rifled through, that was captured on surveillance video. Her ID, her American Express card, and her handbag were in her vehicle, and they were recovered in the possession. Some of that was recovered in the possession of Defendant Phillips. Her vehicle was recovered from 4319 Scott Circle. The Infiniti tracking device on her vehicle tracked it to that location. And Defendant Phillips, and I get into this later, Your Honor, but Defendant Phillips was at the time the girlfriend of Defendant Campbell. Now moving to counts 11 through 14. On January 30th of 2019, officers were dispatched to an abandoned vehicle that was located at the intersection of Howell Mill Road and Peachtree Battle Avenue. The vehicle, which was a 2018 Land Rover Discovery, was left running in the middle of the intersection with damage to the passenger side of the vehicle. That vehicle was totaled as a result of this incident. Officers ran the tag and located the owner, who's Robert Peterson spelled the usual way, and relocated to his residence, which is 953 Peachtree Battle Avenue, which is located in the city of Atlanta in Fulton County. Upon arrival, officers observed that a garage door window had been smashed to gain entry to the garage, and the frame of the garage was damaged as a result of the defendants driving the 2018 Land Rover out of the garage. Upon speaking with Mr. Peterson, the estimated damage exceeds $250,000. Mr. Peterson reported that his wife's 2017 Porsche had also been broken into in the garage, and that a retail package from Norma Kamali, which is a high-end designer, the contents were valued at about $200, was in the front passenger seat of the vehicle and had been taken. Mr. Peterson's neighbor at 949 Peachtree Battle Avenue provided Ring doorbell footage showing a dark Dodge Challenger back into Mr. Peterson's driveway, and two individuals got out. City cameras captured Mr. Peterson's vehicle leaving the victim's driveway at approximately 3:45 a.m. The passenger side door was open as the vehicle left the property. Now I'm going to jump around a little bit because it makes sense as to the facts of the case, Your Honor. I'm going to move to counts 29 through 32. Officers responded on January 30th of 2019 to 735 Montana Road, which is located in the city of Atlanta in Fulton County, and met with the victim of that incident, Luke Bennett. Bennett spelled the usual way. Mr. Bennett stated that he discovered that the door to his 2008 Toyota Sequoia was open, and the driver's side window of his 2011 Honda Odyssey had been broken into. Mr. Bennett reported that his garage remote had been taken out of his Honda Odyssey, and that a Honda generator had been removed from his garage, and they had made entry into his garage as well. Now moving to counts 33 through 34. On January 30th of 2019, officers responded to 2510 Bowler, that's spelled Bohler Road, which is located in the city of Atlanta in Fulton County, where they met with the victim, Jackson Hayes. Mr. Hayes reported that his vehicle had been broken into and his wallet had been stolen. I believe that was a Ford F-250 or F-150 truck. And his wallet containing his ID, cash, and a Wells Fargo debit card had been removed. Now moving to count 35. Officers responded to 1337 Peachtree Battle, which is located in the city of Atlanta in Fulton County, and met with Lawrence Ricks Tucker, who stated that his vehicle had been broken into, another Honda Odyssey, and his garage door opener was missing. Moving to counts 15 through 19. Also on January 30th of 2019, officers were dispatched to 3028 Greendale Drive and met with the victims, Charles and Lynn Morgan. Mr. Morgan reported that his garage window had been busted out and his 2011 Acura MDX had been stolen. Mr. Morgan provided video of the incident, which shows the vehicle leaving the garage around 4 a.m. and being followed by a dark Dodge Challenger. Following that, officers were then dispatched to the residence of Lisa Hill at 3038 Roadhaven. That's RHODENHAVEN Drive, also located in the city of Atlanta in Fulton County. Ms. Hill also stated that her garage window had been busted out and both of her vehicles had been entered, a 2016 Volvo XC9 and a 2006 BMW 533i. They had both been rummaged through, but nothing of value was taken from the vehicles. And finally, officers were then relocated to 3085 Roadhaven Drive, which is the neighbor of Ms. Hill, to speak with Jorge Benitez Zavaleta. Benitez is spelled Benitez, last name Zavaleta. Mr. Benitez stated that his 2018 Mercedes 250 and his 2019 Land Rover Discovery were missing from his garage. The 2000 Acura that had been stolen from Charles and Lynn Morgan was actually outside the property. The vehicles were tracked, both the 2018 Mercedes and the 2019 Land Rover were tracked to 4319 Scott Circle. Officers subsequently responded to that area, including APD, East Point Police Department, and the Georgia State Patrol. On the way, officers were in contact with East Point Police and were live tracking the Land Rover, which appeared to be moving. Trooper Gately with the Georgia State Patrol, along with the assistance of an undercover unit, located the Land Rover. The Land Rover was observed in the Scott Circle apartment complex, approaching the 2018 Mercedes as if it was attempting to park next to it. Upon seeing the marked units approaching, the Land Rover took off and ultimately wrecked out, with the two occupants of the vehicle taking flight. Trooper Gately took custody of Defendant Campbell as he came from the driver's side of the vehicle. Other units pursued the passenger, who was subsequently apprehended and identified as Defendant Hill. Shortly thereafter, officers then located the dark-colored Dodge Challenger, which was also found in close proximity to 4319 Scott Circle. The vehicle that was observed on multiple surveillance videos, it had been stolen out of East Point in the early morning hours of January 30th of 2019 at approximately 12:30 a.m. from a Texaco gas station. Inside the Challenger, officers located a wallet belonging to Robert Peterson and the package taken from his wife's vehicle. Inside the Challenger was also an open pack of orange work gloves and the manual from Mr. Benitez's 2019 Land Rover Discovery. Officers then processed the 2018 Mercedes and located the same pair of a similar pair of orange work gloves that presumably came from the opened pack that was located in the Dodge Challenger. And they also located the driver's manual from Mr. Peterson's stolen Land Rover Discovery. Also inside the 2018 Mercedes was the Honda generator stolen out of the garage at 735 Montana. And the cup holder of the Mercedes was the garage door opener reported stolen from 1337 Peachtree Battle. Defendant Campbell had on his persons the wallet belonging to Charles Morgan, along with the keys to the 2018 Mercedes and credit cards belonging to Mr. Benitez. Defendant Hill had the key fob from Mr. Benitez's stolen Land Rover and Mr. Benitez's ID on his person. He was also in possession of the ID stolen from 2510 Bowler Road. I believe that's Jackson Hayes. Yes, that's Jackson Hayes. Lieutenant Sinks Detective Barry and Officer Severance of the Atlanta Police Department began listening to the jail calls of Defendant Campbell and Defendant Hill. During those calls, it became apparent that Defendant Campbell's girlfriend, Andrea Phillips, who is the third defendant on the indictment, were actively involved in fencing the stolen property during the crime spree, as well as collecting the IDs of the victims. Defendant Phillips was well aware of the crimes that occurred both on January 15th and January 25th, and appears that the three of them were acting in concerts. There are more than 20 jail calls that have been provided to defense counsel that contain statements from Defendant Campbell, Defendant Phillips, and Defendant Hill about their involvement. Defendant Phillips specifically discussed fencing the property through a well-known consignment shop located in Buckhead known as Alexis's Suitcase. Alexis's Suitcase had actually flagged Ms. Phillips for coming into their location and attempting to sell multiple high-end handbags and other items of value over a very short period of time. It is the state's position that between the calls made before her arrest and after her arrest and subsequent to her release from custody, that Defendant Phillips is actively involved, if not the ringleader of the operation. Officers set up a sting operation on February 4th to meet Defendant Phillips to purchase candles, which she advertised for sale on Instagram at Lenox Mall. Upon arrival, Ms. Phillips was arrested by Lieutenant Sinks and Officer Severance. In her possession were gift cards and credit cards belonging to Charles and Lynn Morgan, the Social Security card of Anaya Benitez, and other gift cards that belonged to Miss Benitez. She was also in possession of the handbag and identification of Cheryl Wyndham, who's the victim of the January 25th incident involving Defendant Hill. She was also in possession of the Audi A4 key fob that belongs to Miss Cristiano, and a black Prada handbag and wallet that belonged to Lisa Hill. During the search for vehicle, Defendant Phillips stated to law enforcement that the property in her vehicle was a result of her boyfriend's crime spree of entering autos, specifically referencing Chiquante Campbell. Based on that, Your Honor, and based on the defendant's histories, the state would request sentences as follows. And the state did file its recidivist notice for Defendant Campbell earlier this morning. I made counsel aware of it. He does have 5 prior convictions as follows: 09 SC 84776, obstruction of a law enforcement officer, which is a which was a felony offense. That is from November 13th of 2019. That states Exhibit S1. 10 SC 89280, which is burglary. Although it was a conviction prior to the 2012 amendments, upon reading the indictment, it was a residential burglary. So it would count towards the sentencing enhancements under 1671. And that plea was on April, I believe it's April, I can't see it on the page, but it's either April 1st or April 9th of 2010. He has a conviction for burglary on 11 SC 104403. That was entered into on January 13th of 2012. Upon reviewing the indictment, is also a residential burglary, making this his third, and all subsequent burglaries subject to a sentencing range of 5 to 25 years. He has a conviction on indictment 13 SC 121839 for possession of a firearm by a convicted felon. And pursuant to that, I believe it's 1611-131B. And it's the second part of that subsection that requires that he be sentenced upon a second conviction under that code statute to 5 to 10 years. And last but not least, he has a conviction 16 SC 14481, which he is currently on probation for. He was revoked 2 years prior to this hearing, Your Honor. That conviction was entered on February 16th of 2017 for criminal attempt to commit entering auto, possession of tools for the commission of a crime, willful obstruction, and reckless driving. And I want to say, I think that there might be a 15 SC conviction in there as well, but it's not listed on the state's recidivist notice. Based on that, Your Honor, and because the state is enforcing the recidivist notice, the state would be requesting a sentence of 20 to serve 8 as it relates to defendant Campbell. With the 5 years, so it would be, actually, I'm sorry, it has to be 25 to serve 8.
Because
Of the burglary statute. Upon a third and subsequent conviction, the sentencing range has to be at least 5 years, but no more than 25 years. Because he's an A and C recidivist, he has to be sentenced up to the maximum, even if that sentence is probated.
okay,
And then the 5 years on the possession of a firearm during the commission of a felony, the state would ask for that to be run consecutive but be suspended. And as for defendant Hill, the state,
so I'm sorry, it's really 30 to serve 8.
it's really 30 to serve 8, but that 5 years would be suspended.
Okay. And I believe I could suspend any part of the 17 years after the 8. It's set aside the gun charge.
Yes.
If it was solely the burglary and you recidivize A and C, then it does need to be 25 to serve something.
Yes.
You're saying 8. That range in between those 17 years, you're requesting probation.
Yes.
Is that okay?
But you can suspend it.
Okay.
That's correct. And as for defendant Hill, the state would be requesting a sentence of 20 to serve 7. He has no prior felony convictions. This is his first arrest and first felony case. The reason for why the disparity between the two is, one, Mr. Campbell's sentence is recidivized. Mr. Hill would ultimately be eligible for parole at some point. However, Mr. Hill does carry a significant amount more of the charges, including the most serious charge on the indictment, which is the aggravated assault against Mrs. Wyndham. I have had an opportunity to speak with a lot of the victims at length. There are multiple victims. Mr. Peterson has been actively involved throughout the pendency of this case and is intent on seeing it through. Ms. Wyndham has also been actively involved. She did appear for a motion to suppress ID, which defense counsel withdrew upon her appearance in court. I know that this has been very difficult for Ms. Wyndham because she does take into account the defendant's age and the fact that he does not have a prior felony conviction, any prior felony convictions. Any special conditions of probation the state would request specifically for Mr. Hill that he obtain a GED upon his release from custody should the court enforce a custodial sentence, and stay away from all locations, stay away from all victims, and stay away from the co-defendants.
Do we have any sense where Ms. Phillips is?
Yes, she's at home. She's living with her mother, and she's aware that she has a warrant because I observed the conversation between Mr. Campbell and Ms. Phillips on the jail calls. As Ms. Phillips so eloquently put it, she can't believe that the state is, quote, still bothering with this shit.
So is
So-
her home not in Georgia?
No, she lives in Noonan with her mother.
Okay, but no one's.
No one's gone to pick her up, and she's aware, and her attorney's aware that she has a warrant.
Okay,
It's a pretrial services warrant. Because she violated the terms of her pretrial services bond.
okay. You mentioned in your statement of facts that a detective identified Mr. Hill as the driver of Ms. Wyndham's,
It's Miss Cristiano.
Miss Cristiano, one of the Audis.
Mhm.
He did that because he became familiar with Mr. Hill's face. It
Yes.
wasn't on the spot, oh, I know Hill from something else. It was having become very familiar with Mr. Hill through all these many burglaries and stolen cars.
Yes.
He then said, that's the guy.
Yes, correct. And I did not provide the false information for law enforcement. I did not provide the factual basis for that, Your Honor. But when Mr. Hill was ultimately apprehended, he gave a fake name to, of the name of John Hill to Officer Harrison or Trooper Harrison.
That's count 38?
Yes.
Okay. Mr. Campbell's probation in 16 SC 144481. I've looked at that docket. There was a revocation in March of 2019,
Mm-hmm.
but the revocation order says technical violation only,
That's correct, Your Honor.
and it was for 1 year. It maybe is two, it's hard to read the numbers.
It was 2 years, Your Honor.
Okay, technical violation only is not all these charges.
Correct. And that was a deliberate decision that was made by the state. I was the person that did the probation revocation, because we did it at the jail at that time. And it was going to be too cumbersome to bring in all of the victims and witnesses to do a full probation revocation.
The basis for the technical violation was the arrest for this?
The arrest, and I believe it was also a failure to report.
Okay, that's what it says, FTR, technical violation only. I know for a while at the jail, because of the logistical problems you're describing, even to get one officer in there, the Judge Cottle, was basically stripping off any substantive violation, new charges, and proceeding only on the technicals. This says technical violation only, but you were there.
Yes.
I don't want to subject Mr. Campbell to double jeopardy here, but if he was not in fact revoked because of this conduct, there's another warrant coming and we might as well wrap it up. You think that would be an improper warrant because that informed Judge Campbell's decision, Judge Cottle's decision in February of 2019?
I don't think that would be an improper warrant because I believe the probation warrant was on technicals.
Okay,
So I don't think it would be improper to do that.
okay. Put differently, it may be that Ms. Snyder decides that we ought to sort out the revocation today as well.
Yes, and Your Honor, I would be requesting a restitution hearing as well.
Okay, that was going to be one of my questions, especially when I heard $250,000 damage to a fancy garage.
It was the frame of the garage which impacted the frame of the house.
Sure.
And all of the locations on the January 30th incidents are all located in very close proximity to each other.
It sounded like it.
Yeah.
Okay. You okay? Okay. All right. Mr. Hubbard.
Good afternoon again, Judge.
Afternoon.
Judge, I'll just give you the roadmap for my presentation on behalf of Mr. Hill. I'm going to start off by giving some preliminary comments on the facts of the case. Then I'm going to call one witness. There are several witnesses here in the audience on behalf of Mr. Hill. Then Mr. Hill would like to make a statement to the court. and then I will follow up with some closing remarks and then give the court what I believe is a more reasonable recommendation for a sentence. So with that being said, Judge, the court has the indictment before it. Essentially, there are three dates that criminal conduct occurred on: January the 15th, January the 25th, and January the 30th. I start with the January the 30th because, as Ms. McCauley has indicated to the court, it was the January 30th incident in which a number of burglaries were committed by my client along with co-defendant Campbell. And we would, and I think the facts bear this out, Judge, that there is also a third male subject that was involved and intimately involved in these incidents. And that individual, to my knowledge, has not been identified, nor has he been arrested, of course, because he hadn't been identified. But
so I'm going to pause you
yes.
there when you say not identified, because Mr. Hill has not told you who that was, and you in turn haven't told the state?
No.
Or because the state?
Because Mr. Hill only knows him by nickname. Mr. Hill has consistently indicated to me that this individual is a compatriot, an associate of Mr. Campbell's. And as the court heard during the plea kind of colloquy, Mr. Campbell is 26, and at the time of the arrest, he's 28 years old now. My client was 17. So we're talking about 8-9 year difference in between, in ages. Ms. Phillips is, I think, 27, 28, somewhere in there. She's probably 10 years older than my client. So my client probably clearly should not have been associated or hanging out with these older folks. But the other gentleman, my client does not know, once again, and we've expressed that to the state, and I think the state knows that individual is perhaps associated with Mr. Campbell. But having said that, Judge, it's all of this in terms of how this case came about was once these burglaries occurred on the 30th, it was the vehicle, I believe, of Mr. Peterson, the 2018 Land Rover, that was tracked over into the East Point area. As Ms. McCauley told the court that Mr. Campbell was the driver, identified as the driver of that vehicle. My client was the passenger. When they were arrested in East Point, then the other burglaries and the other incidents from the 15th and the 25th then came to light in terms of them, or law enforcement, when I say them, putting the pieces together and saying, well, these probably were the perpetrators of those because of the similar conduct.
Or because of things found in
And that also. I mean, there were links. Yeah. There were links once they were arrested on the 30th. The reason Mr. Hill and I are asking this court to take an offered plea as to the incidents on the 25th. The incidents on the 25th involved a young lady by the name of Miss Wyndham. I believe it was Miss Wyndham's home along with her husband. I have looked at the video of that incident. Clearly, the individual that got into her car, that entered the garage, got into her car, the individual backed the car out of the garage. Miss Wyndham then comes out, and for less than 2 to 3 seconds, Miss Wyndham is standing in front of the vehicle. This is a nighttime incident. The headlights are on. There is, I believe, right at the edge of the garage, there was a garage light that was lit, but it was not a very well lit area. Miss Wyndham initially described the person as being in his mid-20s. Of course, once again, my client is 17. Scruffy with acne on his face. None of that matches the description of my client. And when she picked him out of the photographic lineup, she said she was fairly certain. It was not 100% that this was the individual. And once again, because of this unknown third party that the state knows was involved, we believe that the evidence could perhaps show that third party was involved in this along with Mr. Campbell, but not Mr. Hill. But given the overwhelming evidence of the January the 30th incident and the fact that Mr. Hill was in fact involved in those, there's no ifs, ands, or buts about that. We feel that if this matter were to go to trial, that there is more than a reasonable possibility that a jury would in fact, given all the facts and circumstances of all the other matters, find him guilty of the Wyndham matter. And so that's why we are asking this court respectfully to take an offered plea from Mr. Hill on the January 25th, 1919 incidents. Having said that, Judge, I would like to recognize for the record that the number of individuals are here for and on behalf and supporting Mr. Hill. Judith Davis is his paternal grandmother, and as I just raised your right hand, his maternal grandmother, Venedra Browner, is here. Kenneth Davis, his great uncle, is here. His mother, Venetia Williams, is here, and his stepfather, Eddie Murmur, correct, is here. And at this time, Judge, Ms. Venedra Browner, his maternal grandmother, would just like to say a few words if the court would allow.
I will allow that, and thank you all for being here. I know these are complicated times to be moving around the city of Atlanta. This is an important situation, so it says a lot to me about family support that Mr. Hill enjoys, that you all are here. You may all want to say something, but if what you're going to say is similar to what I'm about to hear, I'll know that's what you're feeling. But everyone has a right to be heard. And to that note, I forgot to ask you or Ms. Rolak, Ms. McCauley, and we'll do that when we're done with Mr. Hill's presentation, if there are any victim impact statements or anything Ms. Rolak needs to relay.
There is a victim impact statement.
Okay. So, ma'am, you are welcome. If you would come on up to the podium, that way the court reporter can hear you and you can be seen. Thank you. And if you'd start by spelling your name so we get that correctly in the record.
Yes, sir. Good afternoon, Judge. My name is Venedra Browner. It's spelled Venedra. Last name Browner, Browner.
All right. And Ms. Browner, how are you related to Michael Hill?
I'm Michael's grandmother.
Okay. Clearly, you know why we're here today. Is that correct, Ms. Browner?
Yes,
Okay. Michael is accepting responsibility for his role and his conduct in these criminal matters. And it is my understanding that you would like to tell the court something about your grandson prior to this court imposing a sentence, correct?
correct.
Go right ahead and tell the court what you'd like the court to know about Michael.
Well, first of all, I like to say, Michael, I know, Judge, you hear all the time, he's a good kid. They are good kids. This is a good kid, you know. But I want to say for the exception of being a good kid, Michael has a good spirit. He's a good spirited guy. And I just believe that from here on out, we are going to further that. To drive, you know, go in the right direction, and he said that he would, and our and grandma nervous, but like I tell him all the time, when you get a chance to talk to me, and when we get finished talking, I could talk forever, but it's one little piece that we say all the time, and that's the serenity prayer. And with that serenity prayer, it works. Whatever he wants to do or however he wants to do it, I always tell him to use that serenity prayer. And if you can't, you have to accept the things you cannot change. So to me, he's done grown up as a individual. We done crossed from being a boy to a man. So we're gonna have to do what we can further on out. Thank you.
Thank you.
Thank you.
I appreciate you being here and showing support for your grandson.
Exactly. Thank you.
Thank you, Ms. Morano.
Yes.
Michael, you can hear me, correct?
Yes, sir.
You are prepared to make a statement to the court, is that correct?
Yes, sir.
Okay, go right ahead, sir.
Judge, I would like to say that before I was incarcerated, I was weak-minded. Now I see that I was headed down the wrong road to a path of self-destruction. I look at this more like a second chance. I take responsibility of my actions, and I learn from it. I'm looking forward to bettering myself in my future. I'm going to school to complete my GED, and will also get a job and work hard for the things I need in life. I'm thankful, and I now realize that I'm better than the mistakes I've made in my past, and I promise it will never happen again. Thank you for your time.
Thank you, Mr. Hill. I appreciate you sharing that.
Judge, in concluding, Mr. Hill is 18 years old, Judge, but a week from today, he will turn 19. He has turned 18 and perhaps may turn 19 while incarcerated at the Fulton County Jail. He was born in Detroit, Michigan. His mother, who once again is present, Judge, moved to the state of Georgia when Michael was an infant. So he has been here practically all of his life. He has known no other state other than the state of Georgia in terms of his residence. Since he was 13, Judge, I went through a number of medical records that his family provided to me. He has had intermittent treatment for mental health issues. I noted that in middle school, he was diagnosed with ADHD. In October of 2014, he was admitted to Peachford Hospital, being treated for anxiety and depression. In January of 2017, he was admitted into Peachford Hospital again, being treated for psychosis, hallucinations, and paranoia. And lastly, in September of 2017, I believe it is his mother's side of the family that has bipolar issues in their family, and he was diagnosed with a bipolar disorder. And he underwent at that point in time several sessions of individual, what they call psychotherapy at the Family Behavioral Center. I have, over the last 22 months, because Michael has been incarcerated in the Fulton County Jail that long, I visited him no less than 20, 25 times. I have no problem in saying that Michael is lucid. Michael does not appear to suffer from any mental issues as he is in court today. But I would like to, I would obviously like the court to know that this is the individual that, unfortunately, at the age of 17, then chose to make some bad decisions. At the time of his arrest, he's 17. He was residing with his mother and his youngest sister. And as the state has made as a condition of their sentence, that he obtain his GED. He was, in fact, in a GED program that was run by the Atlanta Public School Systems. He was in their GED preparatory program at the time that this arrest occurred. He clearly, in 2019, Judge, made some real poor decisions, real poor choices in getting involved in these criminal activity and this criminal conduct. Clearly, I believe that he was influenced by Ms. Phillips and by Mr. Campbell, who are, 10 years his senior. But as Michael just indicated to the court, he accepts full responsibility for his conduct and for his role in committing these criminal offenses. Once again, he's been in the Fulton County Jail 22 months. While in the jail, and I just went to visit with him yesterday, but there were a number of occasions where I went to visit him when either my visit was delayed or I was actually denied a visit because of things happening on his floor. Michael reports to me that since he's been in jail, about once per week, there is a fight on his floor. Some individuals, inmates are involved in fighting. He reported 5 separate stabbings, and I know the other day, actually this was about a week to 2 weeks ago when I went, that was an issue on his floor, deputies scrambling around, but there had been a stabbing on the very day that I went to visit him. So he's seen this chaos. He's seen what the inside of a jail can do and the conduct that goes on. But in spite of all of that, Judge, he has had no write-ups, he has had no DRs, and he has had no lockdowns in these 22 months that he has been incarcerated. He's not perfect, but he's been a perfect inmate. He is not a perfect individual, as none of us are. He is flawed, as we all are, but I believe his grandmother, his uncle, everyone here in the courtroom that's here to support Michael, we believe that even though he's involved in these criminal matters, Judge, that these acts do not define him. And I think Michael even said that in his statement, that he is not going to be defined by these incidents that he was involved in and that he's admitting to today, but he knows that he can rise above this. And In spite of this, I believe he's an intelligent young man, and I believe he can rise above this criminal conduct and one day get all of this behind him. I shared this with Michael, but one of my grandmother's favorite sayings was that every saint has a past and every sinner has a future. As I sit here in this courtroom today and as Mr. Hill sits at the jail, I believe he has a future. And I believe his future can be bright and it can be productive. There's no doubt in my mind that he is capable of that. I'm respectfully asking this court to consider, and here's my sentence, Judge, that I'm asking this court to consider. I'm asking this court to consider a 15 years to serve 3. The special condition, as the state has mentioned, the GED, no problem. I would ask this court to impose about 100 hours of community service for him to give back to the community. Of course, the restitution is going to be left for a later date, but of course, I'm sure this court would make that joint and several, whatever the number is. He is asking for first offender. I think that speaks to the level of where he is today. I did the calculation and Ms. McCauley shared with me her sentencing guidelines. I think they were a little bit off, not much off, but I think his exposure is about 205 years and 24 months on the counts that he is entering a plea to. He knows, because we've gone through exhaustively and I've explained to him the First Offenders Act. If he messes up while on probation, this court has 205 years of his life. Essentially, this court has his life in its hands. And so he knows the sort of hammer that would be over his head and would continue to be over his head if this court places him on probation and allows him just one chance of getting out here to show this court he can be a productive citizen. I'm also asking a little further than that. In looking at the crime severity levels that promulgated by the Board of Pardons and Paroles, Judge, this court knows, and obviously Ms. McCauley knows, that a residential burglary is a 65% to 90% prison term in terms of what the Board of Pardons and Paroles would look at. I did the calculations on 3 years. In 3 years, 65% would be 1 year and 11 months. I believe he has served just about 1 year and 11 months as we're speaking to this court today and as he is in court today. So this court wouldn't necessarily be giving him any more of a break than what the Board of Pardons and Paroles in their own guidelines has said that they would do on a residential burglary if the court once again imposed the 15 to do 3. The court said a little earlier in another case, I didn't get the gentleman's name, but the court mentioned that you were looking for alternatives simply to locking people up and throwing away the key. I would respectfully request that this court not just impose the 7-year prison sentence. 7 years would mean, according to my calculations, that at the minimum he would serve around 4, if not 5 years of that sentence. He has learned a lesson, Judge. I believe he's learned a lesson, and I'm respectfully asking this court to consider the 15 to do 3 with the other conditions that I've outlined. Thank you, Judge.
Thank you, Mr. Hubbard. I appreciate that. Do you have anything you want to share with me as to how Mr. Hill came to be in Mr. Campbell's orbit or vice versa?
Very good question, Judge. And actually, I had anticipated that question, but I had anticipated Mr. Hill being here in court with me. I have actually never asked him, or if I have my notes, I just don't recall what he told me and what his response was. I'm pretty sure I asked him, how he came into that orbit and circle with Mr. Campbell and Ms. Phillips. I do not have the answer to that question here in court today, Judge.
Okay.
I do, Judge.
McCauley, what's your understanding?
Yeah, so I actually have a phone dump of Mr. Hill's phone. And the phone dump is pretty consistent with a lot of actually the juveniles that I dealt with when I was down in juvenile court and their activities. And it looks like what Mr. Campbell had arranged for Mr. Hill to do would be that he would be the one to steal the cars, and Mr. Campbell would put him in touch with a plug to then sell the cars over to this other person who would then flip the VINs and go forward on that sort of business. It looks like Mr. Campbell might have been on the recruiting side of that.
Okay.
So I did leave out a couple of factual basis for Mr. Campbell's plea. If I could amend the factual basis when the
Good,
court's
I had a
ready.
question, but before we get to, for example, the gun, I need to
Yeah, I
understand.
know. I have a note on here about the gun. I completely overlooked it.
But before we pivot away from Mr. Hill, why don't we get the victim impact statements?
Sure.
I should have asked for those before I turned to Mr. Hubbard. We need to get them all from everyone before we're done. So let's do that,
I believe
please.
Ms. Rolak has them.
Okay. Hello, Ms. Rolak.
Good afternoon, Judge. Judge, I communicated with all of the victims, and they deferred to your judgment or the judgment of the court with regards to sentencing. Most had to say that they will pray for the defendants and hope for the best, that they could turn their lives around. Particularly, Ms. Jennifer Jackson sent in a statement. This is the victim who is spouse to Jackson Hayes. The theft of our property cost us not only money in trying to replace our guns, but the loss of trips we had booked, and we were not able to attend the hunt. We are not able to replace many of our guns that were custom crafted. We would truly like our property back and would like to know if any of the guns have been recovered. Thank you, Jennifer Jackson. That is all I have at this time, Judge.
All right, Ms. Rolak, thank you for your efforts in keeping in contact with the victims in this case. They may be wondering why it takes so long, but of course we're in the midst of complicated times, and we are moving these cases along as promptly as we can, consistent with everyone's due process rights. So thank you again for sharing that information. And for those victims who are listening now, I appreciate very much, one, when victims follow cases, because I rarely get to hear the victim side of the story. The defendant always has a spokesperson in the form of his or her lawyer, and often in the form of himself or herself. The state does a good job of relaying what they know, but it's very helpful to understand the real life impact of crimes like these. It's obvious when someone is shot and they die, someone's lost a life, but just hearing about how one family wasn't able to take a trip that was important to them. That's probably not what Mr. Hill and Mr. Campbell were thinking about when they grabbed what they grabbed, but it upset lives and it affected lives. And in ways even more fundamental than travel that doesn't get to happen, the loss of a sense of security, et cetera. And I'll talk more about that when I'm pronouncing sentence, but it's very helpful to hear from victims. And the second point is, it is always refreshing when victims don't reach out to say, please bury this person under the jail. There are times when that's the appropriate sentence. That's probably not for this. This is a pretty serious collection of burglaries and thefts and whatnot. So it's not a small, simple case, but it is something that I think ultimately Mr. Campbell and Mr. Hill ought to be able to get out from underneath and maybe try to make something of their lives a little ways down the road. And it's refreshing to hear from victims who say they're praying for the defendants that they could do that after they have paid their price for what they did, there is a next chapter for these young men. And that's my hope as well. So thank you, victims, for staying involved. Ms. McCauley, you were going to provide a bit more detail as to Mr. Campbell's charges.
Yes. My
question was about the gun.
That was my issue as well, Judge. So for possession or count 39, theft by receiving stolen property, Mr. Campbell was found in possession of a firearm that belonged to a Parethia Perils, Parthia, Perales. That firearm had been reported stolen out of Rockdale County.
So when Mr. Campbell, who was the driver of the Land Rover that tried to evade the police, when he got out of the car, he was apprehended, and on his person was Ms. Perales's gun.
Yes, that's correct. And there's also a jail call where they discuss how long Mr. Campbell had the gun on his person. That's between Ms. Phillips and Mr. Campbell.
Okay, they share a lot. Thank you. All right, Ms. Snyder.
Yes, Judge. Mr. Campbell is 28 years old and he has 4 children. He has been in continual custody since the day he was arrested. So I'm going to start by asking what we asked for. And understandably, by the law, we have to ask for a 25, but I would ask for 5 to serve, and that for it to be suspended after the successful completion of additional 5 years of probation. Clearly, Mr. Campbell has made some poor choices in his life, but he is expressed to me that he is done with that life. Most recently, when he was in DOC, he finished his GED and he was working in the kitchen on his culinary certificate so he could get a job and be to support his children and be a good father to them.
And Mr. Campbell was in DOC custody because of the revocation?
Yes, Your Honor.
Okay.
So he is looking forward to doing what he needs to do. When he goes back, he can finish his culinary certificate. So he will be a productive member of society when he's released. And he just wanted you to know that he is done with this life. So we would ask that you sentence him to 5 years to serve.
Okay. And did you have anyone, I think there's someone here in court on behalf of Mr. Campbell. So I want to acknowledge that. You are, ma'am, what relation to Mr. Campbell?
I am his grandmother,
Okay, and your last name?
Lewis.
So Ms. Lewis, who is Mr. Campbell's grandmother, is here in court. So I want to recognize that in the same way that it was important that Mr. Hill had family members who came. So thank you.
Mr. Campbell has the support of his sister as well. She calls me a lot.
Okay, well, it's good that folks are keeping tabs. So we've got Ms. Lewis here, Mr. Campbell's sister. Was there anything more you wanted to share, Ms. Snyder, on behalf of Mr. Campbell?
Just that he's expressed to me that he knows he's made some poor choices and he's ready to not be that person anymore.
Okay. I don't know if you've talked with Mr. Campbell about the identity of the third male who was involved. Is that something you've talked to him about and that he is prepared to share with the state, or is that not a popular topic?
We discussed it briefly, but there's stitches get stitches. And it's a nickname as well.
Okay, so we're left with a nickname. Thank you for sharing that. It sounds like, Ms. Snyder, that there is a question about restitution. The state may need to provide more information to you and to Mr. Hubbard. Are you comfortable going forward with sentencing today, and then we might have to amend or modify the sentence if and when there is an adequate showing of restitution?
Yes, sir, we would. Ms. McCauley did indicate when we spoke the other day that we would have a full hearing about it.
And Mr. Hubbard, that works for you as well?
That does, Your Honor.
Okay. So Ms. McCauley, I will rely on you to reach out to Ms. Nelson when you're ready for a restitution hearing and you know that Ms. Snyder and Mr. Hubbard can be involved as well. All right. So Mr. Hill, I'm going to start with you. I have no doubt that your grandmother is spot on when she says you're a good kid, because that's how she sees you and that's how she ought to see you. And she's seen you in a way that, for example, I haven't. My description of you would be you're very polite. You've been very polite during this exchange, as has Mr. Campbell. The problem is, and the reason why you've been sitting in jail for so long, and while you're going to be in jail a little while longer, is that that's only one aspect of who you've been over the last few years. You present a very different face to the many different victims I've heard about today. And to those folks, you're frightening. You represent a violation of their space and their sense of security and the sanctity of their household. And that's not something that you can fix just by saying sorry. And Mr. Campbell, these comments are directed to you as well. I didn't have your grandmother tell me that you're a good kid, and I'm trusting she would say that you've done things that make her proud. Clearly, the two of you are sitting where you are, having done things that make no one here in court particularly proud, probably ashamed, probably concerned. It might be that Mr. Hill's family is upset with Mr. Campbell because they may view that he was a bad influence. But Mr. Hill is sitting there because of actions he took of his own free will. And for both of you, saying sorry and promising to be different in the future, unfortunately, doesn't fix what these victims have gone through. There is that lost sense of security. And I've heard there's certain things that were taken that can't be replaced. It's one thing to steal someone's iPhone. You know what? You can get another iPhone. Whether you pay for it or insurance does, the next iPhone 6 is just like the last iPhone 6. But when you start taking things that have personal or sentimental value so that Ms. Phillips can sell them at a consignment store in Buckhead, there's something lost that can't be given back. And those are tough crimes. And I appreciate that absent the situation that Ms. Wyndham went through, there wasn't anyone who felt physically threatened. It's tough. And we're dealing not with one break-in, one stolen car, one busted garage, but a bunch, and not just on one day. This case is very different from what I typically see, and in a way that is concerning about the defendants and alarming for the community. These are the kinds of cases that we read about on our local bulletin boards where people are saying, you know what, in the middle of the night, someone busted into my car and took this stuff. It's beyond a nuisance crime, and it's a sort of personal well-being crime. And you guys did a whole bunch of these. And that's serious, and there are going to be consequences for that. You're both young enough that you do have a future. You're going to make of it what you will. You're going to decide what that next chapter is, but it is going to be a future that is delayed a bit because there is a price to be paid and deterrence that needs to happen for all the things that went down in January of 2019. Mr. Hill, I do find that there is a factual basis for your pleas. I understand better now why it's an offered plea to the counts involving Ms. Wyndham's car. It's still a plea that you're entering. I need to make sure you understand that an offered plea is basically the way a defendant says, Judge, I don't agree with what the state said happened there, but it's in my best interest to enter a plea anyway. Does that describe your situation?
Yes, sir.
Okay. So it's not that your criminal history is going to show guilty, 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 and then he didn't really do these things. It's going to be, not that anyone's going to divide it up that much, but it's basically, it's guilty to all these things. In the future, it may help you to be able to point out that the court accepted an offered plea to a certain number of counts, but you still get sentenced on those counts. It doesn't really change the outcome other than it's an important way for Mr. Hubbard to share with me why he thinks that if this went to trial, a jury might say Mr. Hill was not involved with that one subset of stealing cars and taking people's property. Given the fact that it's the one where a victim felt physically threatened by what happened, I appreciate why Mr. Hubbard has focused on those. But it sounds like you understand, Mr. Hill, that it still will result in a conviction for you. And Mr. Hubbard, the way I took your description of Mr. Hill's struggles with depression and ADHD, et cetera, were one, it's a real thing, but two, it does not rise to the level where you're concerned about Mr. Hill's ability to comprehend what we're doing and his competency to enter a guilty plea.
Very clear statement and very, very accurate statement, Judge.
Okay. Ms. McCauley may have asked this already. you don't have any issues with, or you waive any issues arising from proceeding on a copy of the indictment.
For the purposes of this plea, Judge, we waive any defects.
Okay. And there may be no defects in the
Well,
indictment.
but we waive one court on a copy.
Okay, great. Mr. Hill, a significant portion of your sentence will be probation. And for that reason, I'm sentencing you pursuant to the Probation Options Management Act. And I'm doing the same for you, Mr. Campbell, so listen to this. All that means is that while you are on probation, if you have a minor or a technical violation, maybe you miss a meeting with a probation officer, or say you tested positive for marijuana, something minor, you and probation sort that out. You don't have to come back in front of me. But if you are arrested for something else, you get in trouble with the law, something like that, that kind of violation will come back in front of me. Mr. Hill, I appreciate your request made through Mr. Hubbard to have you sentenced as a first offender. I'm declining that invitation. If this were a case involving one day of breaking into cars and stealing cars, or maybe a couple cars across 2 days, I might be open to that. But the state, in effect, tried to make things more efficient for everyone by piling all this into one indictment. But you could very easily have been indicted for separate days, for separate vehicles. And it is, in my mind and in my experience, too much to package under first offender. First offender is appropriate for that individual who just took a brief detour away from staying out of trouble. And while one could argue, gosh, it was only a few days in January, this was extensive enough in terms of the number of cars, the number of victims, the number of garages, the value of the property involved, that I think it would be misusing first offender to give you that opportunity. It's not going to change your sentence. It is going to change its impact on you. When you are done with your custodial term, you are going to need to tell folks when you're applying for work or trying to go to school that you're a convicted felon. And that poses obstacles, but I think that that is an appropriate consequence for what you got involved with. Mr. Campbell, you're not eligible first offender, so we don't need to wrestle with that for you. Mr. Hill, the sentence that I'm going to give you overall is 20 years to serve 5 years with the balance probated. I can break it out into all its individual pieces, and I'll do that in a minute. But I wanted you to understand what the sentence was going to be. The special conditions of your probation would be, number one, that you get your GED. And number two, you're going to need to stay away from the addresses of record in this case. I'm not going to put them on the record, but Ms. Nelson can, working with Ms. McCauley, get the addresses for all these victims. Those are places that you are not to go back to. Do we have a sense, Mr. Hubbard, where Mr. Hill will be staying when he's released? I don't need a street address, but is he an Atlanta guy, or is he an East Point guy, or?
Atlanta guy, correct? Atlanta.
Okay, so a brighter line would be to say, stay out of Atlanta, because all these addresses are there, but I'm obviously not going to keep him from his own household. So he'll need to stay away from these addresses and the victims in this case. Before I break down how the sentence is allocated, Mr. Hill, I need to know from you, and you may want to talk for a minute with Mr. Hubbard, whether you even want to go forward. Mr. Hubbard asked for a different sentence, and I understand where it's coming from. I just don't think that it reflects the seriousness of what happened here. You may not feel real fortunate right now, having been in jail for many months and endured the things that Mr. Hubbard described in terms of life in jail. But you ought to feel fortunate that you're actually walking around these days. We read every day about situations where a young man is breaking and entering, and someone lawfully defending his property shoots and kills that intruder. And in any one of these instances, you could have been shot dead perfectly legally. There would be no prosecution of your death, and we would have needlessly lost your life. Your mom would be without a son, and your family would be missing you. And the same goes for Mr. Campbell. That's how dangerous this stuff is. It's not as simple as I made a couple mistakes and I'd really like to move on with the next chapter. So I appreciate where Mr. Hubbard is coming from. I don't think it was an unreasonable request, but it's not the sentence that I think is appropriate given what you were involved with. So you need to tell me if you want to proceed with your plea. You have the ability to withdraw your plea and instead have this case move to trial. Do you need a chance to speak with Mr. Hubbard, or do you know what you want to do?
Is it a chance that I can speak to my attorney, sir?
There is. Let me tell Mr. Campbell what I'm going to do in his case so that he can let me know what he wants to do as well. Mr. Campbell, in the same way, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. I'm also sentencing you pursuant to the Probation Options Management Act. Ms. Snyder, what I propose to do is, how much time remains in the 16 SC case? Officer Crawford?
Yeah,
Or Ms. Snyder, if you know.
give me 1 minute. Let me pull it up for you.
Sure.
I don't think he's got that much, Judge. He only had a 4-year probation.
Okay. It's how much?
6 months and 9 days remaining.
Okay. To keep life simple for Mr. Campbell, given the complications of this case, my proposal would be the sentence I'm about to pronounce, and in light of this new conviction, revoke the balance of the 16 SC case. So we close that out and go from there. But Mr. Campbell, I would be sentencing you pursuant to the Probation Options Management Act. Ms. Snyder, do you waive any issues arising from the fact that we're proceeding on a copy of the indictment?
Yes, Your Honor.
Okay. What I'm going to do in your case, Mr. Campbell, is follow the state's recommendation. Ms. McCauley is closer to what this has meant to the victims, the facts and circumstances of the case. I'll tell you that if this had just been a blind plea with no recommendation from either side, I probably would have sentenced you to a little more, given your criminal history, your age, and my limited understanding of your role vis-a-vis Mr. Hill's role, my less limited understanding of your role and Ms. Phillips's role in all this. I don't think 8 is a small sentence, but I don't know that a higher number would have been real troubling for me if the state had recommended a higher number. So what that means, and what I want you to think about and talk about with Ms. Snyder, is that the sentence that I'd impose would be 8 years to serve. Now, you both get credit for all the time you're in as you're thinking about this. You get credit from the day you were arrested, but it would be, I think it's technically 30 to serve 8. I'm going to be suspending a big chunk of that because I'm not a big fan of 17 years of probation, but that's not what's going to drive your decision-making process. It would be 8 years to serve because of the recidivist notice. So you should talk with Ms. Snyder for a moment about whether you want to proceed with that, or if you think your chances are better by saying no thank you and having this case go to trial. So what we're going to do, and I know everyone's been plugged into this for a while, but we need to do it. We're going to take a quick break and let Mr. Hubbard call to talk to Mr. Hill, and we'll have you call first, sir, because there's only one number. And then Ms. Snyder, when Mr. Hubbard is back, you can speak with Mr. Campbell. And then you all will let me know what it is you want to do.
Can someone provide me with that number?
I will. It is 404
Yes.
612 2392.
Thank you. If I could just be excused to step out in the hallway, Judge.
Yes, sir. We're going to pause briefly. Mr. Forte, if you need to take a break, we'll let that happen.
Mr. Forte? Mr. Forte, do you want me to send you an email with all the names and addresses in it? I don't know if the addresses are, the names should be. Okay. I'll do the same for Miss Nelson. The addresses are not in here. Some of them are, but some of them aren't. Oh, no, the addresses are in here. Oh, good job.
Good job.
I did this on with Joe Hollander over my shoulder in like 20 minutes. Brian, come over here.
So you'll send that to me, Lauren?
Yes, Miss Nelson, I will. I'll send you a list of
Okay.
everything. I'll break it
Okay,
down by
thank you.
count. Yep.
Yeah, I love that mark, that
Mark.
spreadsheet. Yeah.
Little
that's great.
chart. I didn't know. I had to go look it all up. Oh, you're fine. Are you happy?
That's where I would have expected to have been.
Yeah, I don't think you're gonna go into Richardson. 'Cause I think she's gonna ask for Furhan.
I mean, that's fine.
Yeah. So, okay. You're happy though? Do you know anyone else? Do you know if Brian got his letter? Did Adam?
I don't know. I didn't talk to Adam. He had his door closed.
Oh, God. I can't do this.
I was like, he didn't. I said hello. He had I don't know if he had a meeting or what. He's like
Okay.
himself. So I couldn't. But again, I didn't see his face. I couldn't tell.
Okay.
Sleeper got a letter.
And appeals?
Yeah.
Okay, good.
White Nower.
Complex.
Yeah.
Yeah. Farhan, Liz is complex. Elise is staying non-complex. Lindsay McClure's going to non-complex. Shama's staying in complex. I think Matt's staying in complex. He called me, but I haven't asked him, but I'm assuming he's staying in complex with Dunaway.
Yeah, like I'd be good for
Yeah. I don't know if Alice got a letter.
that one. I haven't talked to her.
I haven't heard from Alice. I haven't heard from Gabby. Christina's staying.
Oh, good.
Michelle, I'm assuming Michelle got a letter. Michelle Sims.
Oh, yeah.
Yeah. Charles, has anyone heard from Charles? Or Seth Brown?
No, I haven't.
Jeremy's still waiting on his letter too. But they haven't done DV yet. I think Jeremy's going to DV.
Gotcha.
Yeah. Kelsey, Robert, and Siri are coming to Crimes Against Children. Yeah, I'm excited. That's a good little group.
Yeah, that'll be a good group for you.
Yeah. So,
Just,
yeah.
I have a feeling I'll be writing some memos on some of my cases. Of like,
You should.
this is what we need to do.
You absolutely should.
So like yours, I have two that are gonna go to you, obviously. The one that Jackson Dental was on.
Oh, yeah.
And then there's another one. And Brett really worked that one. I didn't do much with that.
Okay.
But basically it's a legal case. It's like both parents had equal access. So
Yeah, I'll ask Brett about it. I'm meeting with Brett on Friday to talk about juvenile court.
but yeah, I'm excited.
Yeah.
And yeah, if it's half the caseload.
Okay. This is live on YouTube. Thank you, Mary Beth. I didn't know it was live.
Do you buy that by the case?
No.
A whole lot of it. I had to cut myself back. So that one, I got some mornings when I come in here, we know I'm gonna have a long day, and then I brought an extra one today because.
It's a long day.
So we drink them, it's about 4 hours.
Do you have a good one?
So we're ready to go take a nap. I mean, it doesn't affect me that way.
Yeah, that's the only thing I have, I gotta do supporters. That's it. I already have my own career, so. part of this. I can have it out since I'm working, but I just need to make.
Yeah.
All right. Thank you. Bye.
Yep.
Even though you're a fast speaker, you understand very well, you just have to dial for recording.
I get yelled at all the time for how fast I am.
Speaking out at the court reporting in school, they would look at me and they're going, how fast can you talk? And I said, depends on how animated I get.
Well, it helped that I actually wrote out my own factual basis, so, because the police reports are just all over the place.
Right.
Ms. Snyder got off this.
Am I not right?
Yeah, we will enforce it.
Okay, I'll call real quick.
So is Miss Snyder done, or now she's gonna call that?
I think she's gonna call now, just inform
Okay.
you. I just walked back in.
Is it a good connection? You're able to?
Yes, sir.
hear
Yeah,
it?
absolutely. Yeah.
It's been convenient that today they've decided to saw the building in half. Well, we're trying to hear these guys talking through masks 10 feet away from a microphone in a jail courtroom. Did you end up getting any lunch, or are you about to digest your stomach? Good. Sorry about this crazy day. Tomorrow is much calmer. We got a couple civil things. And my guess is that it'll be all virtual and no takedown.
Your Honor, I've had a chance to speak to Mr. Campbell.
Okay,
Well, let's see if we can get everyone back on. All right, we've got everyone back. Are you ready, Mr. Forte? All right, courtroom 2, if you could unmute. Thank you. You're way ahead of me. Mr. Hubbard, you had a chance to speak with Mr. Hill. Is he interested in going forward, or would he like to withdraw his plea at this time?
Judge, not only did I have the opportunity to speak with Mr. Hill, but I did so in the presence of his family members that are here. He would like to go forward with the plea at this time.
Okay. Ms. Snyder, did you have a chance to speak with Mr. Campbell?
I did, and he would first like to request if we could continue this to another day so he has some time to think about your sentence. And if that is not possible, I believe he would like to withdraw his plea, but he would like some time to think about it if Your Honor would allow.
Okay. I don't have an objection to that, but that would depend on whether Ms. McCauley is willing to keep that recommendation open for, we'll call it a few weeks. It's the end of the year, so it may bump over into January. Ms. McCauley?
I don't have a problem keeping it open. That's fine.
Okay, and so we're clear.
Considerable amount of time. I think that's good.
Sure, that offer, given that it's a recidivist number, so it means what it says, that offer or recommendation would stay open. More importantly, my sentence would remain the sentence that I would impose up until the next time we meet. How much time would you like, Ms. Snyder? We're running out of dates in December where we could connect with you and Mr. Campbell. Do we want to do something in January?
I believe the first part of January would be sufficient.
Okay.
Do it before January 18th.
Before the 18th?
Yes.
Okay.
If there may be a switch in people coming in and out, and I know I will not be taking this case on as I move on to other ventures. So I just, like.
Great. It would be, I think, in Mr. Campbell's best interest if we were able to do it before January 18th, so we have the steady hand of Ms. McCauley on the tiller for the state. Do you know, Ms. Snyder, if Mr. Campbell has a preference of being here in person or doing it remotely?
We did not discuss that part of it, but I can definitely have an answer relatively soon. I'm sure I'll be speaking with him a lot between now and then, and I can let Ms. Nelson know. I believe that Zoom should be fine, but if something changes in the meantime, I will definitely let Ms. Nelson know.
Okay. Well, we'll do Zoom as the default because we know we can get Mr. Campbell that way. We may reach a point where we're not transporting inmates back and forth. We had a pause with Union City, and that could happen elsewhere because these are complicated times. So the default would be to get Mr. Campbell on one of our jail Zoom calendars in early January. If you speak with him, Ms. Snyder, and the decision is no, it's more important that he be here in person, you need to let Ms. Nelson know ASAP so we can see if we can make that happen.
Thank you, Judge.
Okay. So Mr. Campbell, you are free to go. We will get you back in this setting, just you, no co-defendants, in early January. We'll just get on the record. It could be a 30-second appearance if you say no thanks. If you say you do want to go forward, then I'll need to actually break the sentence down into the individual counts and say a couple other things about the situation. All right. Thank you.
All right.
Mr. Hill, I'm going to now pronounce the sentence. You should follow along. It is, and Mr. Hubbard, you should follow along. If in any way I impose this in a manner that makes for a sentence that is other than 20 to serve 5, we'll correct it. But I intend, so we're clear, for the overall sentence to be 20 years to serve 5 years. 10 of those years after the 5 will be on probation, and then the final 5 would be suspended. But we'll break that out across counts. Count one, there is no sentence. That's vacated as a matter of law because there has been a plea to counts related to that. Count two, your sentence is 20 years to serve 5 with a balance on probation. And Ms. Nelson, for your purposes, all counts run concurrently for Mr. Hill. He doesn't have any consecutive counts. The sentence for count 3 merges with count 2, so we don't need one there. And count 4 merges with count 2. Count 5 is 6. Count 6 is vacated as a matter of law because there has been an offered plea to the object of that conspiracy. Count 7, while it is an offered plea, is nonetheless a sentence of 20 years to serve 5. 8, 20 years to serve 5. 9 merges with 7. 11 is vacated as a matter of law. 12 is 20 to serve 5. 13, 10 to serve 5. 14 merges with 12.
Can I stop the court there?
You may.
The court said 13 is,
10 to serve 5.
I thought entering an auto was a 1 to 5 claim.
It's a 1 to 10.
I have Mr. Hubbard's recollection, but I'm behind the times with the statute. Let's just figure it out. Although we need to know what the statute was at the time of.
I don't think it's changed.
I may be out of date, but I've got an entering auto that says 1 to 5, but the judge can sentence as to a
You're
misdemeanor.
correct. I don't know why I put 1 to 10.
Okay, that was my good catch.
I
and,
apologize. It's 1 to 5.
Again, so let's just rewind and make sure there wasn't already an entering auto. There was not.
I think that's the first one.
I'll catch them the rest of the way down. So the sentence is to count 13 is 5 years to serve. 14, I mentioned, merges with 12. 15 is vacated. 16 is 20 to serve 5. 17 is 5 to serve. 18 merges with 16. 20, count 20, is 20 to serve 5. Count 21 is 5 to serve. Same with count 22. Count 23 is vacated. Count 24 is vacated. Count 25 is 20 years to serve 5. Count 26 merges with count 25. And 27 merges with count 25. Count 29 is 20 to serve 5. 30 is 5 to serve. 31 is 5 to serve. 32 is 5 to serve. 33 is vacated. 34 and 35 are both 5 to serve. 36 is 12 months to serve. 38 is 12 months to serve. So all those counts run concurrently with each other for a gross sentence of 20 to serve 5, with the next 10 years, so years 6 through 15, are probated and the final 5 years are suspended. What that means, Mr. Hill, is that you will technically still be under sentence a bunch of years from now, but you will not be on supervision. In fact, you may well not be on supervision just a few years into the probated part of your sentence, assuming you've paid restitution. Probation tends not to want to supervise someone who's doing well. So if you are staying out of trouble and you've paid restitution and you're working hard being a law-abiding citizen, your probation may end early and then it's simply suspended. And the importance of the suspended part is that if things aren't going well for you and you start doing this kind of stuff again, I can reimpose a custodial, a prison sentence for both what's on probation and what's suspended.
So I've got 15 years to work with when you're done with the custodial part of your sentence. You will get credit for the time that you've served. And it will be, as I mentioned, a special condition of your probation that you get your GED and that you stay away from the victims in this case, as well as their addresses as they were at the time of these crimes. And those addresses will all be put into the sentencing sheet. They're available in the indictment. Ms. McCauley, any other conditions you'd like to see imposed as to Mr. Hill?
No, Your Honor. Thank you.
I guess I'll add as a condition, no contact with Mr. Campbell and no contact with Ms. Phillips. They go their way, you go your way. Mr. Hubbard, I know you had mentioned community service. I don't think that's necessary in light of the fact that I've imposed a more severe sentence than you asked for. Anything else you want to bring up in connection with Mr. Hill's case?
Nothing further, Judge, but I agree with you. Community service seems not to be appropriate based upon the sentence.
Okay. Mr. Hill, Ms. Browner, family members, this is not the end for Mr. Hill. Yes, he's going to stay in jail a little bit longer. I hope you can understand why. These were serious. We are blessed he wasn't running and gunning and no one got shot. Either he or any of the many victims in this case. But this was real scary stuff. It's very upsetting, and that's too mild a word for all the victims in these cases. And I do believe that this sentence reflects the seriousness of what Mr. Hill got involved with. It's my hope and prayer that he makes different choices going forward, that you all are able to be even more present in his life so that he is not around some of the folks who may have drawn him into this scheme. I don't have any sense that Mr. Hill was the ringleader here. I get it. But it doesn't mean he wasn't an actor and a player in this real scary drama. Mr. Hill, if you were here in court and we had normal times, you would sign this indictment indicating your guilty plea, but you are there at Rice Street. Do you authorize me to sign the indictment on your behalf?
Yes, sir.
Mr. Hubbard, may I sign the indictment on your behalf?
Yes, Your Honor.
And Ms. McCauley?
Yes, sir.
Okay. I think we are done with Mr. Hill's case. It'll take a little while for the final disposition to get done, so don't ask for it right away. But do check it over, Mr. Hubbard, and then we will reconvene. I don't know if it'll be before the 18th of January, so it may be a different prosecutor, but at some point we'll need to reconvene for a restitution hearing. My hope would be that it would be after we sort out what's going on with Mr. Campbell, but it doesn't need to be. We'll make a record at the restitution hearing that I think would shape how Mr. Campbell's attorney would approach restitution. If he's entering a plea, that's up to him. All right. Thank you, everyone.
Thank you, Judge.
Judge,
Yes, ma'am.
the certifieds for Mr. Campbell's plea, do you want me to just hold on to those?
You should hold on to those. I don't get the sense that there's a challenge to his recidivist status, but why don't you hold on to those?
Okay.
I saw that there's already been an entry made in the docket for the notice of recidivism. So there's a record of that already.
Okay.
And query whether I can't take judicial notice of Fulton County convictions anyway, but we don't need to cross that bridge right now.
Okay. Thank you.
All right.
That concludes my business. May I be excused?
You may. Thank you.
Your Honor, is there anyone else you need to speak with?
Let me find out. Thank you for asking. So we do have the rest of this calendar. It sounds like Ms. Paul and Ms. Patel, thank you both for staying on this call. Feel blessed that you didn't have that case. Are we doing something with Mr. Bowden today, or should we wait till Mr. Franklin is in the mix?
Your Honor, I was able to get in touch with Judge Adams's case manager, who said that she's fine handling the revocation with the new case. She just wanted to make sure it wasn't a back to Judge McBurney, which it wasn't. It was a Judge Reader sentence.
Okay.
And Mr. Franklin had believed that that would lend to the best resolution to have them both handle at the same time.
Okay. Do you feel that we need to share that with Mr. Bowden right now?
If he's available, I don't mind scheduling a call with him tomorrow to let him know.
Okay. If you don't mind calling him. Pardon?
We have him.
Okay, let's just put it, you don't mind putting him in front of the camera, it'll take 30 seconds. Thank you. Mr. Forte, you are not going to need to take down anything else that we're doing, so you can start to wind down.
You're all right, likewise, the excuse.
Yes, sir. Good seeing you. Hey, Mr. Bowden, how you doing?
I'm doing fine, sir.
Mr. Bowden, I was just chatting with some of the lawyers who are working on your case, and they shared with me that the judge who's got your new case, it's been indicted now, and it's been assigned to a judge, Judge Adams. She's agreed to handle your revocation as well, so you only have to get in front of one judge and package it all together. So I wanted you to hear from me, Judge McBurney, that this revocation piece, we're going to slide over to Judge Adams so that the lawyer who's helping you in Judge Adams's courtroom can also help you with the revocation, okay?
All right. Yes, sir.
That's it. Ms. Patel, do you want us to have a similarly brief conversation with Mr. Carter?
Yes, Your Honor.
Okay, is Mr. Carter available?
Yes, Your Honor, we're bringing him out now.
Great, thank you.
Bring out cards.
Do you know, Ms. Patel, if anyone has met with Mr. Carter yet in connection with your motion?
No, I don't believe so.
Okay.
And I believe they're only doing Zoom calls at the moment, but I think that there's a little bit of a backlog.
Okay.
Mr. Carter, Your Honor.
Hey, Mr. Carter, how you doing? Mr. Carter, can you hear me?
Yeah, I can hear you.
Okay, good. Mr. Carter, I just want to give you an update. Ms. Patel has talked with your mom about you getting a different lawyer, and it sounds like the family's working on that a little bit. They've been working through some family tragedies, first and foremost. But Ms. Patel has also filed a motion that's probably going to result in a doctor wanting to have a conversation with you. Hopefully you will be willing to speak with the doctor, and your family is going to continue to look into getting you a lawyer. Unless you've got some update beyond that, I just wanted you to know we hadn't forgotten about your case, but it's really up to you and your family as to whether there's going to be another lawyer in the mix, okay?
Yes, sir.
All right, you got any update?
No, sir, I haven't had anything. I've not been able to really use the phone.
Okay, well, hopefully soon you will be able to and talk with your mom. Ms. Patel was talking with your mom. And like I said, there may also be a time when the folks at the jail tell you there's a Zoom call with a doctor, and I encourage you to interact with the doctor too, okay?
Yes, sir.
All right, thank you, Mr. Carter.
All right.
I have pleading for Mr. Cameron's back.
It wouldn't hurt, but I wouldn't, that was a doozy of a transcript. And
I'll put it in all course things, but
yeah,
since some stuff out to the scopes, and that's something I can send it to her for you.
okay. Okay. Ms. Hall, it sounds like Mr. Reed is a reset for counsel. Ms. Snyder, is that correct?
Yes, sir. I spoke to Mr. Dark while we were doing our plea. He texted me to let me know that he had submitted the C3 request. So it should get assigned probably tomorrow.
If Mr. Reed is present, this will be another 30-second one.
Okay, we're getting them out now.
Thank you. And then Ms. Patel, as to Mr. Wilson, is that one we should bump to the new year when Mr. Franklin can plug in, or did you get any update from him?
Based on Ms. Hall's announcement, I do think that it's
Right.
one that we should wait till the new year.
Yep, that's right. I forgot about what Ms. Hall added. Hey, Mr. Reed, how you doing?
Hey, how you doing?
Mr. Reed, I just want to give you an update on your case. The lawyer who we thought was going to handle your case has a conflict because she represented one of the co-defendants in the case. So they put in the paperwork to get a conflict-free lawyer, one who didn't represent someone else in the case, assigned to you. And that should happen in the next day or two. And then we'll be able to move forward with your situation. You'll have a lawyer who can get to know you and the facts of your case, and we'll figure out what we're doing after that person's been assigned, okay? And that person will reach out to you once he or she has been assigned to the case, and you guys can put together a plan of action, all right? Do you have any questions?
How long will this process?
Well, what I've been told is that assignment should be made this week. And then we'll let that lawyer know that he or she needs to get in touch with you to let us know what's next in the case, okay?
Okay.
So you should expect contact from that lawyer sometime soon.
Okay.
All right, thank you.
And the last one will be Wilson if the court would like to see him.
I think we're all set. Well, we might as well. We'll give Mr. Wilson the same opportunity. We are ready for him. Hey, good afternoon, Mr. Wilson. How you doing? Sorry you've been waiting so long. We had a real complicated plea ahead of you. Hey, Mr. Wilson, you are in custody right now because of a probation warrant, and your lawyer, Mr. Franklin, is not available today. He had something come up. But I learned from the prosecutor that they are actually seeking some time on this revocation, which means we need to make sure your lawyer, Mr. Franklin, and you spend some time talking about the case. So I'm going to reset this revocation to a calendar early in January so that Mr. Franklin has an opportunity not only to talk to you, but also to talk to the prosecutor about what's happening with the situation, okay?
May I speak something?
You sure can.
I would just like to say that that during my sentence, when Judge Down sentenced me to this sentence, she told me that I would be sentenced to a 10-1, suspend 5 years on the sentence, and it's currently 2020. It's 2020, which means, you know, sir, you know that the sentence where she told me like after 5 years that the other 5 years would be suspended on the probation, and you know, I just caught this charge in Clayton County. I just caught a new charge in Clayton County, which I pleaded out to a 5-1, you know, and it's just showing. I mean, she told me that I would be done with this whole case in 2020 in the month of July. So I'm just trying to figure. I have another case in South Carolina that's already been handled. Like I just have to get to South Carolina so the charge to be dismissed. Like everything on that South Carolina is handled. I just have to get to South Carolina. So I was just trying to see why would it be time? Why would they be seeking time?
So I hear you. I have two observations. One, you seem like a busy guy if you've got cases in Clayton and South Carolina, so I can understand why Ms. Hall, the prosecutor, is taking this seriously. Second thing, I just pulled up your sentencing sheet, and Judge Downs sentenced you to 10 years to serve 1 with 9 years of probation. And she added a note that says the balance of your probation may be suspended after 5 years of compliance. In other words, you staying out of trouble. My math says you did not stay out of trouble during those 5 years. But that's certainly something for you to share with Mr. Franklin. But I wouldn't get your hopes up that the way Judge Downs structured your case, that there's nothing left to revoke. My guess is that there are a few years left to revoke. But Mr. Franklin is a real good attorney and a smart guy, and he'll talk with you about that, and it may be that there's an angle for you to explore there but we need him to get with you and then get in front of me to have that conversation, okay?
So you said my case would be scheduled to when?
Say that again?
Yeah, I'll be scheduled to when?
Early January, when we get Mr. Franklin back in here, okay? All right, thank you. And I think so. Hold on one second. I just want to thank the folks in courtroom number 2. This was a crazy long day. We got a late start through no fault of yours. Drug court ran late here, and we had a whole bunch of getting folks on that phone line. I appreciate your flexibility, and I know it's late, so get out of here. Appreciate it.
Thank you so much.
And everyone else on the call, it's been a long day for you all. You did not have to be on drug court since 8:30 this morning, but take a break. And I think our next criminal calendar is maybe the morning of the 12th. There's some kind of motion thing. We got a few things next week. So I hope to see some of you next week. Hopefully we don't interrupt Mr. Franklin's vacation too much. But thank you all for your time. And Ms. Nelson, I'll work on getting this link thing working again. Okay? Bye.
Okay, Judge, bye.